All right, good morning. I'm John Blanchard. We're on the record in CB 2017-055490. Johansson and Casavelli, do we have counsel for plaintiff?
Good morning, Your Honor. Yes, this is Brian Easton on behalf of the plaintiffs.
All right, and who do we have from the defendants?
Good morning, Your Honor. This is Nick Caselli.
And good morning, this is Nicolina Castelli.
All right, very good. This is the time set for a trial setting conference in this matter. This is a 2017 case. I think you're on your fifth judge. This case needs to be set for trial. I'm looking at limited options for setting the case for trial. And the best option would be beginning this trial with jury selection on Monday, October 2nd through the 5th, that's Thursday, and then resuming again on the 9th and concluding on the 12th. Mr. Easton, can you tell me why this is a 8-day trial? Is it a lot of witnesses? What's driving that?
I do think there's going to be a lot of documentation, Your Honor, but apart from that, that was what was requested by the defendants and what was granted by the court at their request to have an 8-day trial.
All right. Mr. Casavelli or Ms. Casavelli, whoever wants to answer my question, same question. Why is it an 8-day trial?
Well, he asked for a 4-day, but we didn't get to present our claims, and we do have counterclaims here. And we haven't had much time to develop those.
Do you think it's an 8-day trial, though?
Possibly 6, maybe 8.
Okay. How many witnesses do you anticipate testifying, Mr. Casavelli?
At least I would think 4, maybe 5. Depends on their availability. And it has been 6.5 years.
Yeah, right. Yeah, I get that for sure. Okay. And they may be the same witnesses that are being called by plaintiffs. But Mr. Easton, there may be overlap, but how many witnesses are you thinking in your case in chief?
I would say, and I'm sorry, I kind of got caught by surprise in that, Your Honor, so I haven't thought it through real hard for today's hearing, but I would guesstimate 4 to 6 witnesses on our side.
Okay. Well, it does sound to me to be a fair estimate then, 8-day trial. So we'll set it for October 2nd through the 5th and 9th through the 12th. For the first day of trial, the second is jury selection, so we begin at 8:30. The rest of the day's trial will begin at 9:30. I typically have a morning calendar, trial setting conferences like this, or other matters that I handle in the morning before we start trial at 9:30. Also, we may have things to talk about each morning, touch base on legal issues, how people are doing on time, things like that before we bring the jury in. We don't want to waste the jury's time at all, as you can imagine. Yeah, go ahead, Ms. Casavelli.
When it comes to the jury questions, I've seen a lot of judges have their own set of jury rules that you go by. Do you have anything like that on your bio page that says what you require?
Jury questions, do you mean the questions during jury selection?
Yes, or any other instructions that there might be.
Yeah, let me see if I can answer your question this way. So we don't have, you may or may not know this, but we don't have any more peremptory strikes, what they're called, just your ability to remove a juror just because you've concluded that they won't be a fair juror, just not based on anything they said or did, but just you used to have a right to just remove a juror. Now we only will seat every juror that can be fair to both sides, and that means they don't have any hardship or they don't have any obvious bias. So I start the jury selection process by asking some general questions, some big picture questions to get at those issues, hardship and obvious bias. And then I'll turn it over to Mr. Easton to chat with the jury, asking them questions, and then you'll be able to do the same. As you'll see in the minute entry that'll come out in the next day or two, there's a deadline for submitting what you would like to ask the jury.
Okay.
And those really are up to you. But they should be designed to get at those two key issues, hardship and obvious bias. And Mr. Easton will be able to object to your questions if they're objectionable, and you'll be able to object to what Mr. Easton's proposed jury questions would be. Sometimes I don't allow those questions either because I'm already asking them or I've asked a similar question, and sometimes I'll ask your questions just to streamline things a bit. But we'll talk all about that at the final trial management conference, which will be the next big hearing right before the trial. That was a long answer, Ms. Casavelli. I'm not sure I answered your question. Does that help you, or do you have other questions about that?
No, that's fine. I had forgotten about the preemptive one being taken away.
Yeah, it's kind of an interesting development. In my experience, it means jury selection goes a lot faster. But it also means maybe, and Mr. Easton, I don't know what your thoughts are. It means sometimes people spend more time talking to the jury, getting questions to the jury to tease out whether there's bias or not. But that's the way it goes. And I don't put time restrictions on jury selection because you never know. It's too unpredictable. But my expectation is, and I will push for this on the day of trial, is that we have a jury seated by noon. Sometimes that is not realistic just because, again, it's unpredictable. But I want to start with opening statements and first witnesses on that first day. So that's the expectation. Any questions, Mr. East, about the trial dates or times?
Not about the trial dates or times, Your Honor. Will you be setting any kind of final trial management conference?
I will. I'm going to do that next, but I just want to take it one step at a time. Okay, Mr. or Mrs. Casavelli, any questions about the trial dates or time?
No.
Okay. And as I said, the minute entry that comes out will have all this set forth in detail. But let's do a final trial management conference. That's a 1-hour conference where we will go through all aspects of the trial to make sure that we're all ready. That trial management conference will be on August 4th at 11 a.m. Mr. Easton, does that work for you?
I'm checking, Your Honor. If you give me just a second here.
You bet. Take your time.
Actually, I have a trip planned out of town that week.
That entire week?
Yeah, I believe so. I believe we're going to be out of town. See if I got it on. Check and see if I've got it on the calendar here. Yeah, I'm out of town 7/31 through 8/4. So
okay,
that's
sorry.
I would still be out of town on the 4th of August.
Are you available on the 28th, July 28th?
Yes.
Cassavetes, are you available on July 28 at 11 a.m.?
Yes, Your Honor.
That's fine.
Okay, and that's a 1 hour conference, and it is generally informal to make sure that we're all ready for trial. And you'll see that there will be deadlines, which I'll talk about in a second, for pretrial statements, jury instructions, motions in limine, all that good stuff that we need in advance of trial. And those deadlines and explanations will be in that minute entry. My sense is, and it's a pretty good sense, that the parties have had a difficult time working together on creating a joint pretrial statement. Mr. Easton, I have, I believe, a pretrial statement from you from the last time this case was set for trial. If you want to rely on that, that's fine. If you want to do a new one, let's get that in July 17 as a deadline. And Cassavetes, let's talk about this. My sense is that it would be better if the parties, and this is a lot more work for the court, but I think in this case it might be necessary, is that the parties do separate pretrial statements. And those would be due on July 17th. And then at the final trial management conference on July 28th, we would do some extra work together to resolve disputes that are in that joint pretrial statement, separate pretrial statements. It's a lot more work for me. I'd appreciate a joint pretrial statement, but I can see that that's been difficult. Cassavetes, what are your thoughts?
We didn't say we wouldn't work with him. We just didn't get the opportunity, is what we're stating.
Well, let me put it this way. I would appreciate a joint trial management conference, joint pretrial statement on July 17. But if things break down, I need from the Cassavetes and from your client, Mr. Easton, something from each of you. If it's separate, okay. But if you can do a joint, that's the A+. Mr. Easton, your thoughts on that?
Understood, Your Honor. I know that that's preferred by the court, but I found working with the defendants to be difficult, and I couldn't get a straight answer from them on this last pretrial statement, whether they were going to work with me on it. They requested me to send me what I had, but they didn't give me the information that they were going to actually cooperate on it. So because the court said the deadlines were firm, we should be filing those things, I went ahead and filed what I had. So I don't hold out great hope that we'd be able to get a joint pretrial. But
okay. Well, the more joint you can do, the better. Even if you have some areas of disagreement and you want to file something separately, Mr. and Mrs. Cassavetes, I'll take that. But the more you can do that resolves disputes ahead of the final trial management conference, the better, because we'll be, obviously just every dispute you all have, we need to resolve before we get this to the jury, because it'll waste time if we're talking about the little issues that the jury can't resolve.
And Your Honor, the issue was that joint pretrial statement changed by 19 pages more, and he didn't give us a copy, but the best he asked us to do was send him our portion without ever seeing the new one. That's
against the rules.
That's the reason the request for the Rule 16 conference we have filed with the court is to address those issues in itself.
Okay.
Our part of the joint pretrial depends upon his. They're the ones to initiate according to Rule 16 and to get it to us. Plaintiffs failed to do so.
Well, maybe what'll happen next is Mr. Easton will send a Word version of what was filed, and you can use that as a starting point. But whatever you can do, I will appreciate sincerely. and we'll go from there. And the main issues in that pretrial statement are exhibits. If you're, what happens very frequently, in fact, in the last 3 trials I had, it happened in each one of them. The exhibits were stipulated into evidence. There was no objection. So that saves time with the jury and saves time on the front end. Other things that you'll have to resolve are jury instructions, preliminary and final jury instructions. The preliminary jury instructions are read to the jury at the beginning of the trial, and the final jury instructions are read right before they deliberate. Those are standard. They're called uniform jury instructions, or RAJIs. So I don't have your pretrial statement in front of me, Mr. Easton, but if you identify RAJIs by number, RAJI 3, 7, 9, whatever, that's fine. But eventually I'll need Word versions, a Word copy of all of the jury instructions. So Castavellis, I think you strike me as folks that do a little research, a little Google research ahead of time on these things. You seem familiar with some of these processes. But what I'm saying is the jury instructions aren't written out of whole cloth. They're not something you put together on your own. We have standard jury instructions, and you just need to pick which ones apply to the claims in this case. Does that make sense, Castavellis?
Yes, it does. We do have an issue about this. We'd like to raise in the court on disclosure. You said that the exhibits. We're discovering that most of the exhibits he's claiming in his joint pretrial statement, he's never disclosed to us. And
okay.
That's an issue.
Yeah. So thanks for raising that. That's a good point that is often raised. So discuss that to the extent you can in connection with the joint pretrial statement. Typically what you would have is a list of exhibits from Mr. Easton's side of the case. And then in your column on objections, the objection would be never disclosed. And we would resolve that just by way of example. At the final trial management conference, I would ask Mr. Easton to, for his position, and maybe he'd show me a disclosure statement, or he would show me a letter of transmittal with these documents, whatever it is. And that's just how we would resolve it. Your objections, your evidentiary objections, we resolve all those things at the final trial management conference.
Well, you realize that in prior conference here that he did state that discovery is closed, so that was his position on not disclosing these to us.
Yep.
And so
I understand.
That's where we wish to bring it up now. So.
Yeah, I appreciate the example. It's a good example of how we'll have to address the exhibits at that final trial management conference. So it also is a good example of why it's better if you stipulate, and I get it if you don't, but it just saves time on the trial management conference.
There is one more issue.
Yeah, what's that?
Deposition. We obviously can't get Ms. Johansson's deposition for whatever reason, but we have noticed Garp-Don LLC, their deposition, we noticed on March 28th, and it's been set for April 14th. And we believe that Mr. Easton is going to tell Ms. Johansson not to appear. And he doesn't represent Garp-Don LLC in this matter. So we just let the court know now that if she fails to appear, we would intend to file at least a motion for sanctions and get an order to make the representative for Garp-Don LLC to appear. It's important and imperative that we get this for trial because the majority of the claims from plaintiffs are being claimed by Garp-Don LLC through an assignment of interest, which isn't valid, but that's a different story to argue. But so we need Ms. Johansson's deposition as well as we need Garp-Don LLC's deposition. And that would bring us up to basically 8 hours of deposition time. Mr. Easton picked a tier on this to 30 hours. He's received 8 hours of deposition time, actually more. My wife, Nikki's deposition 4 hours and mine at 4.5 hours. We'd just like to get this deposition without issues and move forward and trying to get a resolution here. And it seems like we may be getting closer to achieving that point with you. And we appreciate this. But we're going to have something that's going to be solid from the court to make Mr. Johansson sit down for a deposition, whether it's for GARP done LLC or for personal. Irrespective of what people may allege what might happen, it's what isn't happening is the issue. And what isn't happening is a deposition. And we need it for trial.
There is another issue with that. We don't ever do video, audio as primary method like he asserts. It's always been additional, and additional doesn't matter, placement and all that.
That is an issue, Your Honor, but we're being punished for our education, but that's being addressed in the
Rule 16.
Yeah, the request for Rule 16 conference. But there's been a lot of things. We're trying to get this moved forward, but we get stopped every time we attempt to move forward. Is our issue that we're blocked on discovery. We issued a subpoena last summer to Verizon Wireless. Mr. Easton contacted Verizon Wireless and objected to the subpoena, and
Discovery's closed.
Stating discovery's closed, Verizon refused to produce the requested production.
And this is a non-party.
Mr. Easton does not represent the Verizon customer. The Verizon customer is not a party to this litigation, and he had no standing to do so, but that's an issue that we're having to go through to deal with these things. And I saw
your Rule 16 motion on the depositions, and I saw, Mr. Easton, you filed a response, and your response was focused on the deposition of your client, and I assume close of discovery issues. But Mr. Casavelli, are you intending to file a reply memo on that pending motion?
Rule 16?
Yeah.
Yes, sir. It's there. We've even emailed the court.
When are you going to do? When will you file that?
On the Rule 16 request for Rule 16?
Yeah.
It was filed on the 3rd, Your Honor, April 3rd.
Okay. Then I just haven't seen it yet. Mr. Easton, do you have his reply memo?
I never received a copy from them, but in reviewing the docket today, I saw it, and I just read it just prior to coming in here.
Okay. I'm not prepared to address it because I haven't seen the reply, but I will read the reply. And if I need oral argument after reading it, I will settle oral argument. Otherwise, I'll issue a ruling on those issues that you've raised. Mr. Casavelli, thank you for reminding me I need to add that to my to-do list. That's good.
Well, we did copy the court, Your Honor, and Provident Law and Mr. Easton on that with it. So because we wasn't sure when it was going to hit the ECR docket.
Gotcha. Okay. Well, he has it now. He says he read it. All right. I will rule on that promptly. I'm looking through my list here. Excuse me while I work through my notes here. Well, Mr. Easton, anything else do you think we need to cover on this trial setting conference?
Not particularly on the trial setting conference. I'll just take issue with some of the issues that were just raised by the Casavellis and Frank that we disagree wholeheartedly.
Didn't understand the
issues. Just putting it on the record.
Okay. Anything else?
We didn't understand what he said, Your Honor.
That's okay. Mr. Easton, anything you want to say? Anything you want to repeat or say on that for the record? And then
I'd be happy to repeat it, Your Honor. We had a plane fly overhead just then, made a lot of noise. I was just putting on the record that I disagree with the issues that were raised by the Casabellis just in the last few minutes here when they were speaking with you. So, and just putting that on the record that we disagree with their position.
Thank you. Mr. and Mrs. Casavelli, we covered a lot of ground today, and I sincerely appreciate your hard work and cooperation getting here. So anything else you'd like to say before we conclude?
Well, I know it's good for October this, but Mr. Easton mentioned something in a prior conference that he has a certified copy of Gary Johansson's death certificate. Just to put it on the record here, nothing supporting the death of Gary Thomas Johansson has ever been submitted on the record, even with requests, and I didn't see if that's in there on the disclosure, the joint or pre-trial statement, whichever you want to call it. And that's, if that's the case, using it at trial shouldn't be allowed if he doesn't disclose first, knowing that he's already mentioned it.
Mentioned the certified copy.
Yes, the certified death certificate. The proper disclosure before trial
is important,
so we can prepare, not last-minute disclosure.
All right, I've heard this issue before. I'm not sure that it's particularly a trial issue because it seems like it's something that's just resolved. But I guess to take that issue off the table once and for all, I'm not sure what you can provide to the defendants, Mr. Easton, to take away that issue from our list of issues.
Your Honor, we would be we would object to providing the certified copy of his death certificate just on the basis that we believe that the defendants have misused my client's sensitive data improperly in the past, and we don't want to provide them any further opportunity to do that. So I don't believe we've disclosed the death certificate. We don't plan on using it at trial. Donna's testimony will testify to the fact that he's deceased, and we have an open probate in Maricopa County that'll say the same thing. So, but the proof that he's deceased.
Do you want to just disclose the probate case number? Maybe that's enough.
We have it, Your Honor. It doesn't say
the defendants have that.
Okay.
Your Honor, we've not used anything of Mr. Johansson's sensitive data, and his speculative allegations is unfounded. And if that's the case, then we request to call Mr. Johansson at trial as a witness, and we'll modify our statements, joint statements as such. Mr. Johansson lives about half a mile from us. We talked to him, and if he can't prove the death because of possibly an altered death certificate, the certified copy is altered, then we reserve the right to call Mr. Johansson. So that's
all right. Yeah. Okay.
Now we would think that the court would say to give that document, since I am agent for Garbine, and I did work for them for 25 months before this issue. Still am an agent for Garbine. And there's not a whole lot of information that we don't already have that we did not abuse, because he submitted no evidence supporting that, just allegations. But that's typical if it's not an email or a minute entry, but that's what we've dealt with for 6.5 years of allegations in that, instead of actual evidence that we can deal with and object to or argue. The issue of it is he's holding information that would prove or at least substantiate that there's possibility that Gary Johansson died. And why he don't want to produce that for his speculative reasons that hasn't been proved is unfounded. And I think we have a right to know that if there's documentation that supports Gary Johansson's demise, especially,
there wouldn't be an issue with him supplying it. If he wants to redact sensitive information, that's fine, but you still need to prove that what you say is true on something.
I would think so. I don't think that's an unreasonable request. unless, of course, the document has been altered. Then I could understand why he wouldn't want to submit it. There are several documents in this litigation that have been altered, and it's provable. We simply request that if it's there, supply it.
That's the reason why you want
Mr. Johansson's been dismissed basically out of this litigation and turned into an estate. I think that we have a right to believe that if he is dead and there's very validated proof, and we're talking to a ghost basically, that they need to prove that he's passed away. Otherwise,
medical examiner never even saw a body, so how do you know for sure?
That's just I think it's fair.
Your Honor, the defendants were the ones that filed a notice of suggestion of death in this case. And then afterwards, we submitted a motion to have the estate entered in as in place of Mr. Johansson because he's deceased. The court's already ruled on this matter.
No, they haven't. No, they have not. Mm-mm. They have not ruled on any matter concerning Mr. Johansson. They just allowed it to be substituted as a...
That's what I'm saying. They've allowed the estate to be substituted.
There was still no evidence of his death submitted. And
so maybe this will be an issue that we have to address again at the final management conference. But I'll just put it this way: I think by virtue of the substitution alone, but in addition, this court sitting here on this trial setting conference, the court is satisfied with the evidence as to whether or not the plaintiff, one of the plaintiffs, is deceased or not. But I think the court can rely on the substitution, the probate counsel, and Mr. Easton's duties to the court. But if this remains an issue, if you think you have evidence that there's fraud there, then I think you'll do what you need to do.
We've submitted video of Mr. Johansson in discovery after his alleged death, 2 years.
2 years after he supposedly died.
And now he is not telling you that. We've disclosed it to him in a disclosure statement. Will we be allowed to play that at trial? Because
it's not a trial issue. No, you'll have to come up with. I don't even know what the motion would be. The court, as I said, is satisfied that the caption is appropriately set and the parties are set. Parties have been substituted. So it's a non-issue for the court. And I'm not sure I can come up with a legal issue for you, but you can do your research and come up with one if you have one.
So you can fake your death and avoid civil action. Good to know.
All right.
That's what this is.
Okay. I think that's everything on my agenda. We'll speak again after the summer or in the end of the summer, and we'll get this to trial and we'll get this to resolution. Go ahead.
If you don't mind the interruption.
Go ahead.
The claims that aren't trial.
The claims that are not triable by jury, you denied the motion to bifurcate. When is the time frame for him to dismiss those claims? And there are a few others that we've noticed that are not triable by jury as well. So what do we do about that?
All of the cases will be tried to the jury. All of the claims will be tried to the jury.
Even the ones that you denied bifurcate? They're
Yes.
not trial to jury, and we never agreed to a jury trial. I mean, to a judge trial.
Oh, wow. That's good to know.
We redid the research, and if you're not bifurcatable, you're not trialable by jury.
The court has concluded that all of the issues can be tried to the jury. All the issues raised in this case.
Even the things that were in summary.
So that the rules and the laws get bypassed on these things?
The jury, the court disagreed with plaintiff's motion and concluded that all of the issues raised in this case can be tried to the jury.
So the court is Okay. I'm not understanding this.
Then you're not understanding the rules, because we read it in the rules that if it's not jury triable ready to begin with,
it's to be dismissed.
It's to be dismissed.
So the court can preempt the rules?
Because you have to
are we
preserve
understanding
the
this
right
correctly?
to a jury trial.
I'm not gonna argue my rulings anymore.
I'm not arguing with you. I'm just trying to ask for clarification and understanding. Can the court preempt the rules that's written?
The court did the court denied plaintiff's motion to bifurcate. The court disagreed with the plaintiff's positions that those claims identified therein were not jury issues. They are jury claims. They will be tried to the jury as a matter of Arizona law. That's what the court concluded, and that's what we're going to do.
Okay.
Okay.
All right. Thank you all. We are adjourned.